Good morning and good evening to everyone. My name is Kritika Rajkumar and I'm the head of legal at CAREspaces. On behalf of CAREspaces and SNS Arts Development Consultancy, I would like to welcome every member of our diverse Indian arts community to the fourth session of our 5-part series, I'm a Professional Too. Our series as a whole places importance on the pillars of ethical professionalism. With SNS, CAREspaces shares the common goal of bringing more accountability and ethical professional practices to our Indian art spaces through this series, and I'm so excited to be co-moderating this Know Your Rights session with Shreya Nagarajan Singh, founder of SNS Arts Development Consultancy. When we all say or hear the words, I'm a professional too, we are committing to providing respect to one another. In our first session, we discussed facets of ethical professional conduct in the context of workspaces. The second session specifically articulated what this respect looks like in terms of accountability and ethical professional conduct in the realm of creative IP, how we can protect our own and respect the IP of others in this space. The third session highlighted what creative, monetary, and other value meant to artists and other stakeholders in the field, as well as the fundamentals of the arts economies of the Carnatic music and Bharatanatyam communities as they currently exist. This session aims to decrease the barriers that exist in accessing legal resources in the context of challenging situations related to IP, breach of contract, sexual and ethical misconduct in the Indian arts, as these issues are the most common issues faced by stakeholders in the Indian art space.
Thank you, Kritika. Hi, my name is Shreya Nagarajan Singh. Before we begin this session, we want to note that this discussion features voices from the creative Indian performing arts, and we understand the privilege that comes with access and proximity to these forms. Although we may come from different ecosystems, this is a safe space, and that's what we're trying to do with this event. So we are all approaching this conversation with mutual respect, empathy, active listening, and believe everyone in this space as equal, regardless of age, gender, or experience. We request both speakers and listeners to do the same. Finally, the information discussed today is for information purposes only and should not be construed. Additionally, any information presented by us, the presenters or hosts, or the panelists through PowerPoints or handouts are for information purposes and should not be relied upon as legal advice. Please be advised that while our panelists are experts in the respective fields, they will not be able to answer any questions pertaining to specific scenarios or give opinions or legal advice around your specific situation. So please refrain from using actual names of people, organizations, or other entities. With that, I would like to brief you all on what's going to happen in today's session. It's going to be in 2 parts. In the first half of our session, we will have 3 lawyers who are experts in their respective fields, and we're going to be doing quickly a frequently asked questions or FAQs about approaching and utilizing a lawyer as a stakeholder in the Indian art space. First, we'll have Rafael Pereira will be speaking from Arunkumar will be speaking from the breach of contracts perspective, and Chetana V will be speaking from the sexual and ethical misconduct perspective. After the first half of the session, the second part of this, we will be exploring some scenarios where we'll have several intersectional issues woven in to see how the stakeholders from the space can navigate various legal opinions available to them from various situations. This is also where we have Rashmi Singh from PCVC who will be joining us. So our team members are also available on the YouTube chat as you all watch the session. So if you have any questions, please type it on the chat and someone will definitely respond. We'll also have a Q&A section perhaps at the end, or we'll be responding to the questions or answers once the session is over. So with that, I'd like to turn to our panelists to please turn on their cameras and quickly introduce themselves, and then we get straight on to the session. So Rafael, can we have you first?
Thanks, Shreya, Kritika, for having me here on the CAREspaces session. Really looking forward to it. My name is Rafael Pereira. I'm the managing partner here at Kinnuts, we're a full service law firm for those in the creative industries. That's what we do 24/7, 7 days a week. As you know, that is the case, at least in media and entertainment. My experience comes both on the business side, from which I have entrepreneurial experience, on the legal and business affairs side within the media and entertainment and music industry. And I'm looking to share my perspective based on this experience of trial and error in the creative industries for the past 14 years now.
Awesome. Thank you so much, Raphael. I think we can move on to Chetna, if you'd like to introduce yourself briefly.
Sure. Hello, thank you for having me. I'm Chetna and I'm an advocate and I'm currently practicing in Chennai. I used to work in a corporate law firm in Bombay, but I moved to Chennai to start litigating in the trial courts, the family court, and also the high court. I mainly deal with matrimonial law issues, issues with respect to sexual harassment in the workplace, domestic violence cases, and also special focus on how to assist members of the LGBTQIA+ community. So I've recently also been awarded a fellowship that permits me to do more pro bono litigation. So that is something very exciting in the trial courts and not as much in the high court. So it's very exciting to see a case from its inception. And I'm really glad to be here with many of my friends here, all experts in their field.
Thank you, Chetna. Arun, do you want to go ahead and introduce yourself?
Hi, thanks for having me here, and thanks Shrey and Kritika for organizing this. Well, I'm Arun. I'm a dual qualified lawyer, qualified in England and India. I'm also a director and head of litigation and dispute resolution with KTS Legal London. I specialize in a wide range of advocacy and advisory work in relation to maritime law, corporate and general commercial law disputes. My main areas of work include a lot of shipping contentious and non-contentious cases, ship sale and purchase, general commercial litigation and arbitration, and media law, of course. Media law specifically in relation to cross-border artists, contracts. It's nice to be here with you all and to talk about a favorite area of law. Thank you.
Thank you so much, Arun. So with that, I think let's, Kritika, if you're okay, let's start with Raphael and with the section about intellectual, with IP and to do with, so Raphael, can we have you on the stage, please? The Zoom stage, yes. Super, so can we just quickly start perhaps about just discussing a little bit about what types of law you practice and also at TINNUTS, and also when would somebody approach you to use your services and in what type of scenarios?
Well, at TINNUTS, we're full service for those in the creative industries, regardless of what body of law your problem relates to. We're here to support you, whether that is through our strengths in-house with our associates in-house or our affiliates and associates that we have relationships outside. So how we're structured, I take care of most of the intellectual property, the business law, the media and entertainment law, a bit of criminal law related matters, because that's where I got a lot of experience while I was in law school and straight out of it as well. Our partners are into family law, personal law, and civil law related aspects. So if you're an artist, I'd like to tell people we can help you get married, get divorced, build your estate, advise you on your will, of course, help you make money with your agreements, whatever they may be, talent, production, publishing, recording, and then help you register your trademarks, your copyright, and help you effectively put in a strategy to protect your IP and then monetize that as well. So we're not a huge firm trying to take over the legal services industry. All we want to do is take over the creative industries.
That's great. I love that. I love that you have such a broad array of services that you offer for creatives. And I specifically want to ask you, you talked a lot about what you do offer, but when would people not approach an IP lawyer like yourself? Can you sort of list out some scenarios where you wouldn't be able to help them?
Well, I guess in maritime disputes, that's something I can't help with, and then you reach out to Arun. That's not something that I would generally advise on. If it's a pure what we sometimes refer to as serious crimes or hard crimes matter, and you're not an existing client of ours, I wouldn't expect you to reach out. I have no shame in admitting that there may be those who are better suited to assist you in those matters. The reason we handle matters of criminal nature for our clients is because we know their history, their background, the sensitivities that come with their profile, and then we're able to select good counsels to represent them, to brief them well, things like that. So our strength, I've explained what our strength is, and once you're within let's say circle, then we can handle A to Z for you. But if let's say our relationship doesn't start on business law or IP law relating to the creative industries, then I would say you can look for alternate counsel to represent you first for those matters, because it's we'd both be on par, starting out from scratch, getting to know you and getting to know your matter.
Awesome. So when someone decides that they want to have a meeting with you, what types of things would you recommend that they bring with them? And I know this could be specific to the type of case that they are bringing before you, but generally, what types of things are helpful to bring to a meeting with a lawyer like yourself?
Firstly, what I would advise is while seeking a meeting, we have the misconception, or not the misconception, for a large part it's true, but people are very scared of reaching out to a lawyer because they feel every second speaking to a lawyer is kind of draining their bank account. So we don't follow the practice of the billable hour. We're more of a fixed fee solution oriented firm. So for initial consultations, and at least to get to know what the problem is before we can even decide. So for preliminaries and things like that, we're not here to charge you. What we're here to do is understand your problem and then let you know if we can take it on. And then our fees are associated with our solution or implementing the solution. So what's most important, I feel, for a potential client to do is be calm, be composed, and just collect the material and know that the matter that you'd like to discuss with us, you just, and be objective. I know it's tough, but try and it's all in your head, right? And no one knows your matter better than you. We could be seeing it through to success, but you'll still know your matter the best. I would say that in an initial briefing or in initial conversations, it's important to not necessarily submit evidence or just submit copies. If you feel that the matter, to understand the problem, you need to rely on a lot of documents, or someone needs to read I would need to read the documents. Let me know, or let the person you're speaking to know. Ask them if it's okay to send the documents in advance. Let them know that you'd like it to be privileged and confidential. Then send it to them, let them read, and then join you for the conversation. That will also make it more fruitful for you. It's a judicious use of time. And that's what I would recommend.
Thank you also for telling us a little bit about the costing, because that's also a question that we get asked a lot. So I'm glad to know that you charge in terms of fixed fees, and once I guess you accept a case. So just some follow-up questions, building on this a little bit. From an IP perspective, what do you think are the pros and cons of artists putting their content online versus live performance? Because we all know in the live performance, it's an experience, it's a one-time thing. Like nobody's going to remember, let's say, a certain choreographed movement or a certain song or lyrics or anything of that sort. But online, it sort of stays forever, and it's much more easier for people to sort of take from that. So, what would be your thoughts in that situation?
I would take off from what you just said of it being easier, right? And I would ask, why is it easier to go online? Well, let's first start with understanding offline. And offline, the environment of performances in the creative industries function under blanket licenses that are issued through PROs, which are performance rights organizations, or CMOs as they are known in Europe, collective management organizations. And especially for music, these organizations give out blanket licenses that allow you to play any form of music, any type of music. And I mean, often it is assumed that any kind of music means any music, even though it may not be represented by the PRO or CMO. So it's kind of like a cushioning that we have in an offline world. Come pandemic, we've all seen artists complaining of takedowns online, and we've seen streams go off or get muted and things like that. And I'll touch upon, when you said it was easier. Yes, it is easy to, we have ease of access to just go ahead. We've gone from the whole technology as a read-only mechanism to a read-write mechanism today, right? Anyone with a camera can now go live, and that's great. But what platforms like YouTube and TikTok have also done is they've put blanket licenses in place, just like the PROs and CMOs have done on ground. So you can create a dance TikTok with the most popular song out there, but know that TikTok has gone and paid millions of dollars to the label and the publisher that owns that song, so that you're able to go out there and dance. And there is a high chance that a specific song, let's say a folk song, Shreya, if you take a folk song and you've created a TikTok with that song, there's a high chance that TikTok doesn't have a license for it. So that artist is not going to, or the rights holder of that song is not going to see any money from your TikTok being created. And that's kind of where we find ourselves today as creators as well, right? We have the means to operate in a read-write system, which I love. It's great. This is how it should be. But we are also cushioned, and a lot of things are blanket deals, which are done, let's say, through the back door, which users don't tend to know about. And that not knowing about it results in a lack of education, and then also a lack of empathy, I would say. I'd go so far as to say that, because if you don't know a right exists, there's there's no chance of you knowing that that you're going to infringe a right as well. So that's what I feel about these blanket licenses as well, that they don't let creators know that certain types of rights exist, and that conscious thought of, am I allowed to, does not manifest in the creator's head. And I believe there needs to be a lot more talk about this, and we need to go back to a system of am I allowed to, which we've seen in broadcast, right? You had VJs, and you had people who part of reality shows who wanted to do crazy stuff, but there you always had someone from standards and protocol or business affairs coming and saying, hey, I don't know if we're allowed to do that. Okay, let's skip that, let's cut that. And with everything going digital today, we do see this, specifically when when companies are doing corporate shows on their microsites, we do see those questions being asked. But in the larger scheme of things on the YouTube and TikTok, I think where the bulk of creators and the most amazing creators in the world are, we're kind of losing out there.
Awesome. Thank you so much. That was really, really helpful. And I know that with the increased likelihood that you're going to have more art made, you also have more art that's being consumed by a lot of people. And consumers of art are also really, really important stakeholder in the Indian art space. So I kind of want to shift gears and ask you very briefly, kind of as consumers of art, if we see IP violations, for example, you gave that example on TikTok where if someone sees that a folk artist's song is being used and maybe they have the knowledge that, hey, maybe this person is not being paid any money for the usage of the song, what are some active steps that consumers of art can take to help creatives in protecting their IP rights?
Report is the name of the game today. Also writing to the artists, we've seen many call out on Instagram and Twitter, directing traffic or attention to a particular issue, and that has really helped. As a consumer, yes, it is your responsibility, and I believe, you know, when we had to overcome physical piracy in India, we always let the consumer go very easily. But you know, consumers need to be vigilant, and they need to take some responsibility in pointing things out as well, especially with the tech ecosystems and platforms that we have today. So report, flag it, let others in your community know. We've had some great examples. Like one example I'd like to share is there's an artist, Parafakuva, who had used a sample of a folk musician in one of his songs, and he believed he had cleared it by paying a certain rights holder, but that rights holder had not cleared it with the artist. So it was only till someone pointed it out on social media did even Parafakuva find out that it was not cleared, and then they contacted the artist who featured in the sample and got the artist paid, got a license and things like that. So yes, the consumer is really important in this whole process.
Awesome. And to sort of close out your part of the introduction, I kind of want to ask you, what does justice look like in this space? So let's say a creative or somebody else decides to pursue an IP action. What sorts of remedies are available if someone wins their case, or if they decide to take legal action?
Firstly, if you decide to take legal action for copyright and trademark related matters, you have both criminal remedy as well as civil. Depending on where you are, your criminal remedy could be quite effective. You have police units that are sensitized and also specifically trained now in intellectual property infringement matters. So they know how to register a complaint, they know what questions to ask you, they know how to do a raid in the matter, and things like that. In civil, certain matters with a certain value go straight to the High Court. Intellectual property, commercial suits, at least in the Bombay High Court, you know, the High Court has large inherent powers as well. So getting an injunction, that we have seen High Courts, provided you go in at a reasonable issue injunctions also, stopping a film from being released. One example is, if you've seen Bad Boy Billionaires on Netflix, it was originally slated to have 4 episodes, and only 3 are up there. That's because the 4th episode is still tied up in litigation. And that's the real, that's the ultimate recourse and result. I can say, if you can, that's a Bad Boy Billionaire. I'll give later on a few more examples of how the little guy can be protected as well, and hopefully that will help everyone watching.
Thank you, Raphael. What we'll do now is we'll just shift gears to Chetna, but Raphael, we're going to be definitely bringing you back to continue this conversation about IP. So Chetna, Thank you so much for and so she will be talking today about giving a perspective of the sexual and ethical misconduct area of the law. So perhaps, Chetna, before we start, maybe you can give us a general summary of your expertise and how you can help stakeholders in the Indian art space.
Sure. I'm not associated with a firm or with a group of people. Litigation is sometimes what you do on your own and you take up cases on your own. So I'm working with a senior now and taking up cases on my own. So like I already said before, I mainly deal with matrimonial law issues, domestic violence cases, sexual harassment issues, in some cases POCSO, that is Protection of Children from Sexual Offences Act. If a child who's under the age of 18 has been subjected to sexual abuse, the judicial process is a little different from other criminal cases. And they also do other criminal cases. So it's quite hard to point my finger on this is what I exactly do, because as a litigating lawyer, you're supposed to take on everything that comes to you. But something that I do not do and I do not specialize in would be corporate commercial law. So that is something that I will probably not be able to give advice on. But personal laws and issues pertaining to sexual harassment in the workplace is something that I advise on in India. With respect to the arts field, I just want to put this out there that I will be talking about things with respect to sexual abuse and sexual harassment. So in case that triggers something, it's probably best you put me on mute for the next 15 minutes. And if you do have anything that you want to address in person, I'm sure Shreya can pass on my email ID and that person can be in touch with me. If this is something that they cannot sit through, I completely understand. So the arts field in general, in my opinion, is extremely difficult to navigate through with respect to sexual harassment and interpersonal difficulties, because there is a lot of trust that goes on between two people associated in an art form. And with respect to dances and with respect to music itself, you have a lot of one-on-one sessions. You have a lot of practices late into the night. It's most often you and that other person in an auditorium. In dances, you come in contact with someone. So that element of contact and touch is present there, which you do not find in a normal corporate workspace. So what I can say with certainty might amount to sexual harassment in the workplace need not necessarily apply in arts, which is why you find a lot of artists who have been subject to sexual harassment keep thinking, is this part of my rehearsal or is this something that shouldn't have happened to me, right? So the best way to identify if something has gone wrong is that touch was not welcome and that there was no consent with respect to that. So as soon as you feel that way, you know that something is not right. That's where your problem starts. This need not be the same for everybody. It's extremely subjective and it's very personal. So when you have a complaint of sexual harassment or when you feel that there's a misconduct that you have suffered, it is not good for you, your mental health, to compare notes with others on is this something that amounts to harassment? Because at the end of the day, if this is something you feel is not right or not normal, you can approach a lawyer with certainty. And the lawyer may be able to tell you whether or not you stand a chance in court or whether or not this problem has a legal defense, but that does not negate the abuse or harassment you would have suffered. So I just want to make that very clear, Shreya.
That's great. That's very, very useful to know. And a sort of a follow-up to that, at what point would someone come to you specifically? Because something happens to somebody, they're obviously distraught, they're not sure, and you deal with a lot of clients who have gone through some pretty traumatic experiences. So who do they go to first? Do they go to a police officer? Do they come to you? What would your best practice be in that situation for who they should approach?
Some people come to me after they've not had much success in the police station. Some people come to me because their therapist has recommended that this is something you have to speak to a lawyer about. Some people come to me because their parents or their friends would have told them you have to see a lawyer now. And some people come out of their own volition, saying that, and many times I have seen that people narrate first-hand accounts of violence to me, something that they have not opened about to anybody else. And it all just comes out in a flow because they simply don't know who to go to. So at that point, I can tell them that, look, this is a legal issue. This is something I can help you with. But what you're dealing as a consequence of this is not something I can help you with. And you need to find professional treatment. You need to go to therapy. You need to go to a doctor to figure that part out. But with respect to the first, let's see what we can do. So that's what I do. And a person, yeah, they come to me at different stages of the problem. They come to me at the beginning, they come to me in the middle. And at the end of the day, it's for you to find out what that person wants from the case.
So one of the big issues perhaps we also face in this space is really about evidence, right, regarding a case or a scenario, especially in the arts, like you mentioned, that we work in silos and it's usually very intimate spaces. And the people who commit these crimes know that, right? They know that you're going to be alone backstage, etc. So how do we sort of, what options does a survivor have in terms of navigating evidence, and what if they have no evidence? Like, what is this issue? What happens then?
So that's a great point, Shreya, because many times people come to me saying that, look, this happened, but I haven't come forward for so long because there's absolutely no proof. And to which my answer would be, you don't go through your entire life with your phone on record mode thinking that something would happen to you, right? Most of these instances of sexual assault and violence have happened in closed quarters where you are cut out from the rest of the world. In the art spaces, it sometimes even happens during rehearsals. It happens in the backstage. It happens in the green room. It happens when you're commuting from one performance venue to another, in a lack of supervision, or there are no CCTV cameras in these places to find out what happens. So a reassuring fact is that in the Prevention of Sexual Harassment in the Workplace Act, it clearly states that inability to substantiate the complaint does not mean it's a false complaint. And I think that's very important to remember, is that even the law doesn't expect you to always have screenshots of everything, video recording of everything. No. So, and with respect to sexual violence in rape cases and rape trials, it's a settled position of law that if the victim's statement is clear and coherent, and even in the absence of any other evidence, that statement alone can be relied on by the prosecution. So that's something that's important to note and remember. And with respect to evidence, I just tell people that, look, it's okay if you don't have any evidence. If you feel that you can proceed with this case, this is what this case is going to entail. And I'm very honest with them about how the court systems work. And I'm very honest about how even an internal committee filled with people might look at their complaint. Like if it's a woman who has had casual sex in the past, who has had multiple partners, but yet has been dealing with an act of harassment, I do tell her to be prepared for judgment that can come from all corners. So this is something that they have to know before they proceed into any kind of legal solution to their matter. So also with this, I just also want to add that different people have different ideas of what solution is to them and what the outcome of the case is to them. Under the POSH Act, that is the Prevention of Sexual Harassment in the Workplace, an important option that's given to the parties is conciliation. So this means that even before an inquiry proceeding starts, a complaint is given to the Internal Complaints Committee. And before that inquiry proceeding starts with respect to the complaint, the victim has an option to sit with the person accused of the offense, along with the members of the Internal Complaints Committee, and talk about what happened. Money cannot be a reason to come to a conclusion in these conciliation proceedings, but many times what the victim wants is an apology, a sorry, and that this will not happen again. And if this is something that can happen, be given in conciliation, then there is a possibility that the inquiry proceeding itself need not happen. Because closure looks different in these cases of misconduct to different people. So if someone wants to see their case through, that's up to them. If somebody doesn't have the emotional, financial, or the caste privilege to stand up to all this and they just want to put past them and move on with their career, conciliation is also an option. So in these cases, we need to keep in mind that the outcome can be different for different people. And a lawyer will always suggest the multiple avenues that the person has before they make a determination on what they want to pursue.
That's really helpful. And I know the POSH Act specifically protects workplaces, right? So can you speak a little bit about how that would apply in the Indian arts context, because we often, our spaces are, in their current state, extremely informal. We create art in informal spaces. We don't have an office per se. We don't have an HR committee. We don't have a governing body. We don't even have a union for all intents and purposes, like a lot of other actors unions and other types of creative performers have. So can you speak a little bit about how the protections of the POSH Act apply or don't apply at all in our art spaces, and sort of the best practices that you would suggest for a creative to use given these informal spaces that we have?
That's a really good question. And I think I also want to cover how kids are taught music or dance or arts in general in the Indian classical music background, in addition to how performances happen, right? Absolutely right. It is very informal. So there is no internal committee that exists with, if let's say there's a certain performance that happens on a stage and a technician is subjected to harassment from a performing artist, or what are their remedies available to them? Who can they go to and say, look, I've faced an act of sexual misconduct? So under the POSH Act, there's a local complaints committee that's set up. So any place that has 10 or more people employed has to have an internal complaints committee. Most of the times, all the sabhas and the organizations that do set up in order for these musicians to perform don't actually have people employed on their payroll per se. They are most often part-time workers or they're contractual workers. So there is a loophole there. But if they do have 10 or more people they engage, they're supposed to have a POSH policy and internal complaints committee, but that rarely happens. So the other option they have is to approach the local complaints committee, which should be present in every district on paper. But sadly, at least in Tamil Nadu, that's not yet implemented properly. I'm not too sure how it is in the rest of the world. So that is something that I don't think exists as a mechanism in real life for them to go give the complaint to. So in this lack of structure and this informal place, POSH has little to no relevance, because you do not know who you can file this complaint with. You do not know who's going to sit for your inquiry proceedings. Unless that happens and unless everybody comes together and says that this is our policy, this is our committee, please approach them. These are the following organizations who will fall under the umbrella of this. I don't see much happening in the future. However, after 2013, the Nirbhaya case, our Indian criminal laws have been amended to include sexual harassment, to include stalking, to include acid attacks as criminal offenses, which previously didn't exist. So it's also open to now the parties to go file a first information report with the police station if something like this has happened to them, and if the ICC doesn't exist or is not active.
So just two more questions before we wrap up, Chitna. One is question of minors, right? Because a lot of the classes, what does the law say in terms of if you're a teacher, especially bringing a lot of minors together and taking responsibility for who's in that space and their safety, and the opposite of if you're a minor and let's say there is a complaint and they take it to the teacher or to the parent, what happens then? That was one question. The second question is really a little bit more towards costs, right? So let's say you do raise a complaint like this, you're a parent, you're also worrying not only about what's happening in terms of socially and what everybody's going to say or how you're going to be perceived because of this complaint, but also the costs involved of going to a lawyer and taking this to court, etc., or even filing an FIR. What are those sort of, what does that look like as well?
Okay, so with respect to children, we just briefly touched upon the POCSO Act, the Protection of Children from Sexual Offences. I'll just be going into it very briefly. It's a penal statute, and anybody under the age of 18 is a child in India. There are multiple explanation of what constitutes sexual assault. It's an umbrella. It's penetrative sexual assault. It's sexual assault. It's sexual harassment. There are different degrees of punishment and different degrees of acts about what happened to the child. For example, groping the breast. All this are also because in most cases, at least in the performing arts field, it's quite rare to see a case of outright penetrative sexual assault. It's more or less things like this, touching a child's genitalia over their pants or groping their breasts, which you see most of the times that happens. These are things that fall under the ambit of the POCSO Act. Now, there is mandatory reporting under the Act. The child can report, the parents can report, the teacher can report. If you come to hear of an instance where a child could be subject to violence, you will have to report. Now, second thing with respect to the cost is that, see, this is a crime. So usually in crimes, you will not be conducting the case. The case will be conducted by a public prosecutor who will be appointed by the state. So they will be in charge of conducting the entire proceedings. However, under the Act, you have an option to assist the prosecution. So you can engage, if you are the child's parents, or if you want better representation, you want to know what's happening in court daily, and you want to assist the court better, you can request the court to assist the prosecution. So the prosecution will be conducting the case, and you can have your own lawyer to assist them. They cannot make submissions in open court. They can see what's happening, and at the end, after the trial ends, they can give written submissions to the court. The court can consider that while passing a verdict of guilty or innocent to the person. With respect to costs, again, there is free legal aid that every Indian citizen is supposed to be entitled to. You can approach the legal service authorities. The legal service authorities are available district level, state level, and the central level. And their contact details are pretty much in the public domain. So they can also be approached in case you need to. And you can tell the court you want free legal aid, and the court can appoint a legal service lawyer for you.
That's really, really helpful. And we actually have a question from one of our RSVP forum attendees. And so I think this is really, really important. So I wanted to make sure that we covered this with you before we move on to Arun. But the question is, survivors could be worried about conflicts of interest in the current ICC that is said to be present in the Indian Arts Sabhas. So are there certain qualifications or parameters for internal complaints committees? What parameters are needed to set that up? And do these parameters change for a government organization versus a private dance school, et cetera? And if you could just, sort of give an overall summary, and this person can definitely follow up with you if they have questions post the session too. But just so we have an idea of how that would be set up.
Sure. So I know my time's up, so I'll be very quick about it. You need a minimum of 4 people to constitute an internal complaints committee under the Act. More than half have to be women. So a minimum of 4 people. If there are 4 people, 3 of them to be women. The presiding officer should be a senior woman at the workplace. The other 2 should be people who belong to the workplace. And finally, you need to have an external member who's a lawyer. It can be a person associated in the NGO field. It should basically be someone from outside the field that you are looking at here. So this absolutely changes in the art space, but the minimum number of members and the presence of an external member will remain constant. So let's say you're faced with an internal committee which is 2 people. No, that's not a valid constitution, and you can raise concerns about it. If there is a conflict of interest, out of 4 people, let's say the complaint is against someone, and the person sitting on the committee is someone who has engaged that artist repeatedly, consecutively for many, many years, and you know they're good friends. So what do you do in this case? You can give a written representation to the internal complaints committee that you feel there might be bias and that you would like that one person to be changed. It's within your rights to do it, and you can ask them. Whether they will or they will not is a different question. And if they don't, you can definitely contest it later, saying that you have asked them about it, you were afraid of bias. And so that's definitely something that can happen. What was the second part of it about the internal complaints committee? And
yeah, so the second part of the question was, so you talked about the parameters and the qualifications, et cetera, but the fact that survivors could be worried about conflict of interest in the current ICC. So, and that is set to be present in the Indian Arts Sabhas. So they've sort of identified, they know the parameters, they've identified that there's a conflict of interest. So who do they go to?
No, the second part was whether it will be different in a government organization.
Oh, yes. Yeah.
Okay.
Whether it would be different in a government setting versus a private dance class or any of that. So public versus private sector.
Okay, so when you come to the government, it's a slightly different playing field, because government employees, center and state, are different. They have their own conduct rules, and in the conduct rules, Usually in cases of sexual harassment, an inquiry officer is appointed to investigate the proceedings. So it's slightly different from what is there in the POSH Act, but the basic tenets of the POSH Act will hold true because that's a special legislation intended to cover sexual harassment. So with respect to government organization, yes, it will be a little different, but it cannot be completely against the tenets of the POSH Act. And I think we've also covered how to deal with bias and how to, switch out a member of the internal committee if you want.
Awesome. Thank you so much, Chetna. You've given us so much valuable information in such a short span of time, and we really, really appreciate that. Let's switch gears now to Arunkumar, who is going to be speaking to us from the breach of contract perspective. Arun, thank you so much for joining us today. And we just want you to kind of go through a general summary of your expertise, what kind of law you practice, who would use your services, the cases that you work with, and sort of relate it to the stakeholders in the Indian art space and when they would approach you for help.
Sure. I briefly gave areas of law I practice, so I'm just going to focus on the media law aspect of things. So I have represented actors, writers, directors in relation to their contracts, either with the producers or with Amazon Prime or with Netflix or with their agents. So we have also assisted a lot of ceramic artists in relation to their cross-border contractual disputes, especially with the wholesale buyer in China. And I also have worked in matters in relation to disputes between concert organizers and service providers, especially in Singapore, where we had A.R. Rahman's concert, and there were like problems related to microphones not working and stage lights going off. So these kind of things come up and we assist them, though it's interesting to say that it's more into contractual disputes rather than media law per se, but you need to have the basic understanding of media law in order to advise these. Our firm especially advises a lot of artists and people who migrate to UK, who come here to perform. We have an immigration law department who do that part of work. That's all I can think of now.
Awesome. Thank you so much. So we have a couple of follow-up questions, sort of more specific to your practice. And
sure.
One of the very common things in this space is that there is sort of a stigma associated with signing contracts, because many of the people in the space are close friends, confidants. They work together all the time, but first and foremost, they're friends in the space because they've either learned music or danced together, or they perform very, very frequently together. So what would be sort of your advice if there's no written contract and there's only very often WhatsApp messages or email informal communications that establish a technically contractual relationship? So what would be your advice in those situations?
Sure. This is something which I come across quite often, like there are like few things which I have to speak about here. A lot of artists I work with, they always go on like how I'm going to ask for a contract. I know this guy for years. It's based on trust and continuous relationship. And I always tell them, everything is bed of roses until issues come up. That's when you're like crying about the fact that you never had a contract. And we try to look for messages here and there to put together something to defend their rights. I believe that signing a contract can be very important as it provides proof of the agreement made between yourself and another party. And there is also, when you have a signed contract, there is a less risk of a dispute between the parties because the terms of the agreement sets out clearly from the beginning how things are done. There is also a disadvantage when people sign contracts, especially when they don't read the terms of the contract. Like even a lot of us, including lawyers, when we sign up an online service, we just go click, yes, I agree, without reading through the terms and conditions for the services provided online, which happens a lot. And I know some artists who blindly sign the contract saying like, oh, what if the person thinks bad about me if I just look through the terms of the contract, but they don't realize they need to protect themselves, so at the end of the day, you are the best person to take care of your interest and no one else is going to look out for your interests. So So it's something I always tell them, like, read through the contract before signing. If you're signing one, if you're not thinking of signing one, please ask them to provide you with a contract and sign one. With regard to the WhatsApp messages, which is like varying the terms of the contract, or where there is evidence to show there was a contract. In England, it can be used as evidence before the courts of law, but in India, recently in July 2021, the Supreme Court said that messages exchanged on social media platform have no evidential value, and that the author of such messages cannot be tied to them, especially in business partnership governed by agreements. This is a statement which was thrown by the Chief Justice of India in one of the matters he was presiding. And it has not been explored yet in relation to different areas of law, but this is a statement which has been given. So it might be difficult going forward to prove that there is a variation which happened using WhatsApp messages. And most of the contracts will provide that if you're varying your terms, it has to be written, and it has to be mutual, like both parties had to sign to it. So these are the problems which arise when there is WhatsApp messages. But usually I tell my clients, when they have a written contract, later they vary the terms by a telephone call or an in-person meeting, just go back and just drop an email or a message to the other side to say that, hey, we just met. I would like to summarize what we discussed. These are the things we discussed, and I would like you to confirm to it. If you do not reply, I deem that you agree to this, like something in those lines, at least it will have a persuasive value to when we are trying to protect your rights before the court. It will show the intention of the parties. And whether it will hold as an evidence before the court of law depends on the facts and circumstances of the case, and other things has to be taken into account as well. But at least it has some kind of persuasive value to it. And I think I have answered most of your questions, but if I missed out something, please let me know, and I'll be glad to clarify.
So one question that you remember, you're talking about being mutual, is that there are many situations where you're signing a contract with somebody who's much more senior than you, either in experience or in age or a very big venue, let's say. And it often, we all know, right, because we've read so many contracts, that the contract is always going to favor one person than the other. It's a question of trying to bring it as close as an equal as possible. So the question is, if you're a younger artist and you're handed these terms, and what are some tips that you can give them in terms of negotiating, or even taking that step saying, hey, maybe I can change this, or maybe we can change that? How does, let's say, somebody who doesn't have the power as the other person, they're getting into contract, would deal with it?
Yeah, it's a very interesting thing you told me, that you raised this question, because I was thinking of saying this as well. Like, it's always good to have a lawyer when you're drafting a contract. Because it will work cheaper for you to draft a contract rather than hiring a lawyer to deal with the breach of contract or enforcing a contract. So it's advisable that you get a lawyer well in advance. So he does your negotiation. He advises you on like clauses which is working in your favor, which is against you, so that you can talk to the other side in a way. I mean, usually we will advise them like what strategies they can use when they are negotiating with the other side, and it will come handy to talk in that way to get what you are looking for. Obviously, a lot of young artists get influenced by the seniors, and the best way to go about is refusal to sign the contract or voicing it out. Because once you sign the contract and later it might be difficult for you to get out of it unless you can show that you were under duress or undue influence while you entered into this contract. It depends on the facts surrounding each and every case, So it's always best before you enter into the contract, get an advice with a lawyer, advise you on your rights and on the specific terms of the contract. So it helps a lot.
And I know that that this is something that we don't often think about, but a contract isn't null or void or not enforceable just because a lawyer didn't write it. I think that's also important for us to sort of say. It's not that you can't write a contract without a lawyer. It's that a lawyer is going to probably do a better job walking you through exactly what you need. So I think that's the emphasis that we want to place here. It's that, yes, if you don't have time, something written by you is definitely better than nothing at all. But if you do have the chance, definitely consult a lawyer, because it'll make your life a lot easier. Something that I wanted to ask you is, I know in your introduction previously, you talked about the fact that you deal with a lot of overseas contracts, and you represent people in all different kinds of jurisdictions. So in our space, something that often happens is we have maybe an Indian artist traveling abroad, or an American artist traveling to India or to any other country. And we kind of want to ask you, what happens when different stakeholders breach their contracts overseas? Like, what does that process look like? Let's say, for the sake of example, that an Indian artist breaches their contract in the United States. What are the steps that would happen, like in terms of enforcing the contract and navigating how that breach happened?
Right. I cannot advise on US, but I can give an example, the same example, we can apply it to UK. Say if there is a written contract, we have to look into like what's the governing law of the contract, because when there is more than one party from different jurisdictions are involved, then there will be an agreement towards the governing law, then there will be a jurisdiction clause, and there will be a dispute resolution clause. And usually when there is a cross-border contract, we always advise them to use English law, and we always advise them to use arbitration clause, because to enforce an arbitration award is a lot more easier than enforcing a judgment in various jurisdictions, you know. So when, for instance, let's take the scenario where an artist enters into an agreement with a UK-based company, and the contract says like it will be governed by English law, English courts will have jurisdiction, and any disputes have to be tried before the English courts. So ideally, when the artist breaches the contract, goes back to India, the people here will initiate they have to send the letter before claim, which they will send it probably by email to the artist. And if he doesn't respond, then they will initiate a claim before the courts in England based on the value of the contract, value of the claim and everything. And once the claim is issued, it has to be served through a process server out of jurisdiction. So they have to get the permission of the court in order to serve these claim documents in India through the proper service procedure applicable under the Indian law. And once that's done, the artists have X number of days to reply. And when he fails to reply, the contractor here in UK can enforce a default judgment against this artist. And once the judgment is obtained, they have to take this judgment to India, register with the local courts here in order to enforce this judgment against the artist. So it's a long process which happens. And so, yeah, there is provisions which shows that if there is a breach in the cross-border contracts, you can get your right, you can enforce it against the person, but it's going to take a lot of cost and time. And then it also, you have to consider the fact whether the artist has the means to pay back the contractual sums and all the legal costs involved and the court fees, etc., etc.
Hello?
Yeah, I can hear you.
Yeah. Sorry, my internet's going in and out. So Arun, there's some very good points you raised there, and I think we all sort of keep, I mean, I personally can say that I, for example, go to a lawyer to get my contracts drafted when I'm going into into a business with a new client, or if it's for a client. So I would like to talk a little bit about costs here, just to give our listeners an idea of what it might cost to go to a lawyer. And most lawyers for their first session don't charge anything. And that's what I always tell my clients is, don't worry, nobody's going to charge you for the first time. They're first just going to have a conversation. And then at the company, they'll tell you how much everything is going to cost. So let's say I'm an artist and I want to draft a contract, like you said. What are some of the costs that we're looking at, let's say in Indian rupees? Okay.
Well, I cannot give a blank figure like a lump sum for this, because it depends on each contract, depends on on the complexity of things, but for instance, if it's only to do with Indian parties, it's better off to find an Indian law firm to provide you with the services, because they will be better equipped to do it. But if it's cross-border and if you want to engage our services, then we have like various options for the cost, like where we either charge you based on our hours, or we can agree on a fixed fee. And then we also provide, like, you can pay us in installments, like in three installments or 4 installments, like that. And if there is a breach of contract and you want to enforce your right, and it's a lump sum case where we are talking in terms of like lakhs and lakhs or crores, then in UK there are like litigation funders who will fund your litigation. And so you can approach us and we will get you a funder based on the strengths of your case, and they will fund your case, and whatever the winnings you get, they get a percentage out of it. So that works as well. So yeah, there are various methods by which we can assist you if you're not in a position to immediately pay the cost.
So one last question, maybe it's irrelevant, but I just want to, so when I'm entering into a contract, whose responsibility is it to make the contract? Is it whoever is the bigger party, or whose job is it to bring the contract to the table? Or it doesn't matter, any one of the two parties or multiple parties can bring the contract to the table?
It doesn't matter, anyone can bring it, like any party can initiate it, and they say like, I want to have a contract. So it doesn't matter whether you're a junior, senior, what's your background.
Thank you so much, Arun. We have more questions regarding contract, and especially regarding breach of contract, because we all know everybody gets into a contract when everything terms are great and everything's hunky-dory, but when you break that contract, and that's really the question, and we have some scenarios regarding that, which I'm sure we'll bring you back up. But right now, thank you so much, and we'd love to bring Rashmi Singh from PCVC onto the Zoom stage, please. Let's see, Rashmi. Hi, Rashmi. Rashmi, thank you for joining us from very smoky Delhi. I hope you're feeling okay.
Smoky and slowly winter's approaching. So
exactly. So we just want to quickly, before we start your quick session, can you please tell us a little bit about yourself and the work that you do, and especially with regards to PCVC, so we can give everybody a little bit of context before we jump in.
Okay. Hi, everyone. And thanks for having me here. So I have been working in the social development sector, particularly on the issue of gender and violence against women for almost now 2 decades. Every time when I say this, I feel, oh my God, I'm now getting old. So so largely when I started working on this issue, it was basically with some of the funding or the donor organizations who put in resources for projects on ending violence against women. But for the last 7 years, I have been closely associated with the organization based in Chennai, International Foundation for Crime Prevention and Victim Care. The organization came into existence way back in 2001, and it's a specialist organization. And I can very proudly and confidently say that it is one of the very, very, very few organizations in India who is providing extensive support services to women and now to LGBTQI individuals as well, who are basically survivors and victims of intimate partner violence, domestic violence, etc. And our services entail right from 24 hours by 7 Dhwani hotline, which is now popularly known as the Dhwani domestic violence hotline. And then, of course, as we always say, that a phone number is not enough. What happens after the person calls on a helpline? And that is applicable to any kind of such support. And then after that, we also have, in order to create that kind of a back-end support. We have a shelter, which is like a crisis home shelter. We have a very nuanced and very survivor-centric, psychosocial interventions. We use a lot of art therapy for various interventions. And of course, then it is about linking women to skill building and economic empowerment, because over the years we have learned that one is, of course, the person will reach out when the person is in crisis, when there is a threat to their life, or they have been asked to leave the house. But ultimately, if the goal of the organization is that how they do not re-enter that cycle of violence, I think a much long-term comprehensive support is needed. And that's why we popularly call our model as from a victim to a survivor to a thriver. So yeah, so this is who we are, and our purpose of existence. Happy to take other questions.
Awesome. Thank you.
Go on, Kritika.
Sorry. Thank you so much for that context. And Shreya, I think you had a few follow-up questions for Rashmi, so go ahead.
No, I was just wanting to ask a few things regarding, let's say, lawyers, right? As one of this, let's say you have an experience of sexual misconduct, one of the things you can go to somebody like a Chetna and get counsel. So when do they go to a lawyer versus when do they come to an organization like PCVC? What are some of the scenarios that you see in terms of, what are some of the scenarios that people can come to you for? And how does it work in terms of costs and things like that? Can you tell us a little bit?
So I have been listening to the conversation, and largely, we've been having from the last 1 hour or so, largely around workspaces. But as I said, PCVC is an organization providing support for DV survivors or intimate partner violence. But definitely an issue like workplace harassment, sexual harassment does come, and I will tell you when it comes. So that's a separate thing. But going to the legal support and when people approach PCVC, this I would like to tell you from our experience and our journey and story of PCVC, that yes, definitely when we talk of a very rights-based approach, and from a justice point of view, definitely we need the law. And especially in a country like India, where there is no dearth of laws, it is a lot of time, it is gap in their implementation rather than the absence of the law itself. But what we have learned in this journey, Shreya, largely is that it takes a lot for a person to take a legal recourse. And also, many a time we have seen an individual that the moment the person realizes that something which I'm facing, whether it is at workplace or within the four walls of the home, the first thing which becomes many a time a deterrent for the person to reach out for support is they feel going out, speaking up and taking support means just the legal recourse. That's the only option. And I think that's where an organization like PCVC comes in. So we sometimes we call ourselves as a facilitator organization, because even if a woman has to take I wouldn't say just woman, but any individual who wants to take a legal recourse, I think the first thing is that they have to, they sometimes they just want to come out of that situation first to be able to take a more informed decision. Many a time they have children, they have other family members, and as a result of that, many a time they feel I can't take a legal action, because then what will happen? I don't have the money to do that. I don't have that kind of a support from the community. Many a time it happens that if a person wants to take a legal support, the first question sometimes it comes is, okay, the moment the person who's abusing will come to know, the first thing will be, where will I go?
Right.
And especially this happens a lot in DV and intimate partner violence case, but then this is also happens in the cases of sexual harassment. A lot of time people don't complain because then the chances of retaliation many times are very high. So I think the back-end support is something which an organization like PCVC provides. And I would say, just to put that in a couple of words, is that enabling and bringing that readiness in the person to be able to take the legal recourse. I think that's what an organization like PCVC does, and that's what we feel. And taking a legal recourse is only given as one of the options. I remember like a lot of clients, first time when they are calling, they will call on the phone and they will say, "Theek hai, this is what I'm going through, but then will I have to go to a police station? Will I have to file a complaint against the family or to the employer or whoever?" And if that's the way, I don't want to go. I don't think I'm ready for that. I just want someone to talk. So I think when you say a safe space to talk, that's where I think an organization like PCVC comes. And then I think it's a very multi-pronged approach. So you need the community support, an organization, a civil society organization support. We need lawyers and legal bodies on board. And that's what we have also in PCVC. We have a lot of lawyers on board. So we are not saying, okay, we know it all. A lot of people have, another example is that as a result of abuse and violence, they have a lot of mental health issues. So we have psychologists and psychiatrists on board. So I think, that's the kind of role the organization plays, and that's who we are. Going to your question on how much is cost, for anyone to access PCVC direct services, there is no cost at all, because one is that this is something which we always feel that the financial part and this kind of a thing should be kept separate. The other is we are a non-profit organization, so we have donors who support the work we do. So whatever services which are offered, but of course, if there are some very specialized services, let's say we need to have a lawyer and the person cannot afford, then either PCVC will pay or we have lawyers on pro bono basis. And sometimes we've also had people who are from a socio-economic background where they're able to afford. They say, okay, I want a good lawyer, but then I can pay. So that also happens, but not to the services which are offered directly at PCVC. There's no money, the fee for that.
Awesome. Thank you so much for giving us that context. It's extremely helpful, and it's so great that you have services that any kind of person can use. And I think that's going to be really, really helpful when we talk through these complex scenarios that we have coming up. So we've structured this section of our event to feature you as sort of a liaison to legal resources, which is what you described a little bit. And Shreya and I are going to read a hypothetical case scenario that involves some complex intersectional factors. And we'd love to hear how you would then guide an individual in that situation and how you would act as a bridge between them and the lawyers that we're going to bring up to the stage, or other resources that you know of, because some situations may not have a legal answer. And to all the lawyers here, we'd like to hear how you would be involved in such cases and any best practice suggestions you have pertaining to the case. And Shreya and I will then follow up with any additional questions we have, and we'll spend about 15 minutes on each case. Before we begin the scenarios, just a reminder that the information discussed today is for informational purposes only and should not be construed as legal advice. Additionally, any information presented by CAREspaces or the panelists through the PowerPoints or handouts are for informational purposes only and should not be relied upon as legal advice. And please be advised, while our panelists are experts in their respective fields, they won't be able to answer questions pertaining to specific scenarios or give opinions or legal advice around your specific situation. So when you ask your questions, please refrain from using any actual names of people, organizations, or other entities. And we're going to have a content warning before each scenario. So please feel free to pause the video or skip ahead for any scenario that makes you feel uncomfortable. And all scenarios are hypothetical and are not based on real life accounts or real people. So with that, let's bring up whoever we need to the stage. And we're going to start with the first scenario. I think Shreya is going to read out the first scenario. And then at the end of it, anyone who wants to jump in can go ahead. So Shreya, take it away.
Thank you, Kritika. Okay, so this is the first scenario. A trans woman from a religious minority is denied a performance opportunity as a dancer for a prestigious dance institution in India that is staging a dance ballet production. When asked, the producer explains that the person does not, quote unquote, fit the look for the leading female role of this dance production, because the producer wants someone who looks more feminine. Despite being a renowned dancer and equally qualified amongst her colleagues, this is the situation of the scenario. But both men and women were allowed to audition for the role. So how should the dancer proceed? I welcome all of you to turn on your cameras and be on the stage, and any one of you can answer as to how you can respond.
Yeah, with respect to the discrimination angle in this, it's quite implicit, it's not direct, but since both male and female participants were allowed to take part and a trans woman was explicitly ignored, it is something you can raise. But then again, like what Rashmi beautifully pointed out, not all problems have a legal solution when you deal with such sensitive issues. And as a lawyer, it would be my advice to this person that this is better tackled going to grassroots organizations and stirring up support from within the community, both the dancer community and the LGBTQ community, and pursue a direct legal remedy to it. Because one, that is quite remote. Two, it can take a very long time. Three, it can exhaust you of resources. And four, a lot of things in the art community is extremely reputation driven and your personal equation with somebody else. If you want an opportunity to perform again, you may not want to, slap a lawsuit against this person. So you have to consider all those things being an artist yourself, especially one from a marginalized community. So I would suggest that this person also, as a lawyer, I would suggest that they take screenshots of the production calls where it shows that both men and women are allowed. If, let's say, their fellow dancers have tagged themselves in certain Instagram posts of going to this audition and performing, and if there are men in that can also be used to further substantiate what they feel on a public platform, which is necessarily not a court.
Rashmi, given that Chetna has said that perhaps going through grassroots organizations or a nonprofit organization would be the best recourse, which is where you come in, how would you help someone in this situation?
So I think Chetna already said what I wanted to. So I think that's the role PCVC would play. So I was just trying to visualize that what if, like on the Dhwani hotline, this call comes. Sometime, I think long time back, I would say, if suppose such a call came, I remember some of the counselors responded, but then this is not a DV case, or this is not an intimate partner violence case, right? But then we have also learned in this journey that even if it is not a domestic violence case or it's not an intimate partner violence case, but then it is a case which is a case of gender-based violence and gender-based discrimination, that is what the organization is there for. So in this case, I think once the person calls, and I'll just tell you what systematically will happen. So one is, of course, the counselor at the other hand is going to listen to the entire case, and then, of course, our normal thing is what the person would like to do. So sometimes the person will just say, I just wanted to share with you, are there any laws for that? So of course, we will try to connect the person with the lawyer, and then the lawyer can tell them that this is under this law, this can be covered, or something like that. Or sometimes the person, we've had cases where the person said, I don't want to do anything, but it is really impacting me a lot, and I just feel rejected. It is having a lot of psychosocial impact. Then, of course, we have series of psychosocial interventions with that person. I remember we've had cases where we have also engaged with the employer or with the institution as a civil society organization, and we've had representative from their organization coming down to PCVC, and we've had this conversation also. So because this doesn't come under, I would say, the POSH Act per se, because at the moment it just says it is for women. So I think these are some of the support things. So basically facilitating the process based on what the person chooses to do, or what the person think that they would like to do at that point of time. And especially in this case, actually there is no law at the moment. So what we were just talking about it is that how do we mobilize others in the community, because there are a lot of organizations who are working on the issues of LGBTQI rights. So even like talking to them, and then, because it is also important that you just can't say, okay, this doesn't come under any law, then we can't do anything. But I think if we go back down to the history of how various laws came into existence, there were cases on the basis of that certain laws came. Like even if we look at the POSH Act, it happened because of Bhavri Devi's case in Rajasthan. So sometime you don't know, some judgment will come based on discrimination. So I think that is what the course PCVC like an organization will take.
Also, if I can just add one thing, with the advent of the Transgender Protection Act and rules, it's a legislation I have many problems with, but they do envisage setting up a nodal authority to assist in implementation of acts for the trans community. So, maybe a written representation there wouldn't hurt also. And also, it's very important to note regional influences. If this is an incident that happened in Chennai, there is a very active transgender community here. There's a transgender welfare board that has been established even before the NALSA judgment came into existence, and they will actively assist any member who has been subject to harassment. So it's not just you can't limit yourself to the scope of a national legislation. You need to look at your regional community influences. In Mumbai, for example, there are many pockets of very active communities in this regard. So you can't restrict yourself with national or international NGOs. You need to look at regional NGOs who can assist you. Even with PCVC, I think I've dealt with 3 cases of LGBTQIA+ people. It's always important to have the counselor online, ma'am. I mean, even as a lawyer, I always, request that they stay online so they can better communicate what I want to speak. In one such case, especially a trans man who felt discriminated by his family, a little different from what we're establishing here, wanted to file a case for maintenance against his family because they were harassing him. But in my opinion, that would not have panned out because he was a healthy, active 24-year-old, and whatever barriers he faced is not something that court can sympathize with at that point. So I know that he needed to be taken to a safe location. So I called PCVC and I requested if they can keep him in their shelter home until he finds his feet, and they agreed to it. So having an organization like PCVC, even as a lawyer, and when you know that a legal solution won't pan out, but how can you best keep that person safe and further harm, as you see with many survivors, organizations like PCVC can be of massive help.
I think that's really, really awesome, because I think it's really important for our viewers to hear this, especially because there's so much fear in whether you're going to the right person. But I think the answer is that all of these professionals are just people that can point you in the right direction, no matter what your issue is. And so you should never be afraid to approach PCVC. It's okay if you're approaching the wrong person. If they're an educated person who knows about your rights, then they can definitely point you in the right direction. And so I think that's really, really important to establish here, that you shouldn't fear reaching out because you're not sure if someone can help you, because the chances are they all know each other and they're all connected. So that's a really, really important point that you made. I kind of want to go back a little bit to something, Chetna, that you said earlier, is that in this particular scenario, you said it's very, very implicit, the discrimination that's happening. So can you speak a little bit about sort of how high that standard is to show that discrimination happened in a particular situation? Kind of what sorts of things can someone look for in terms of like red flags, saying like a case may be quote unquote stronger than another? I know you don't like to say that any case is strong or weak, but can you just sort of talk about that very high burden or standard that someone needs to go through to show that something was discriminatory? Because I think it's important for our listeners to understand what they're working against in a particular situation.
Sure, sure. And I think Rafael can also help me here since he deals with a fair bit of criminal law. So I'll just be very brief here. Right now, I don't think the system is one that's sensitive enough to deal with such, like, let's say you're not cut out for this role, even though you have men and women auditioning. So I don't think we're at a stage in a legal system yet where we can go and say, look, I've been discriminated against, even though we all know that that's the truth. So what in this case, what would amount to as discrimination is if there were slurs thrown at this person on the basis of their gender identity and who they choose to be. If they are directly restricted entry into, then they're saying, no, this is only for men and women. Why are you as a trans woman auditioning for this? If some things are being made more clear on the basis of their gender identity, then it's something that would be, I don't know, I really don't like using this word, but yes, stronger in this case. In here, there is more an angle of the producer's own idea of who he feels is the right person to cast. So there is an element of power he's giving himself in this equation, saying it's my creative choice. At the end of the day, I'm an artist, and as an artist, this is who I feel will best suit the role. So the element of discrimination kind of gets hidden here, even though it is there and it is alive. So in these cases, like I said, it's good to show that he's not just auditioning women for this role, he's also auditioning men for this role. And the only reason that you're being denied entry, even though you're an experienced dancer with so many years of production under your belt, is that there's no real reason for him to reject you other than this gender identity that you have.
Yeah, that's great. And I think it's also important to point out that all of these situations are jurisdiction specific, right? So while in this particular jurisdiction, let's say we're in India here, it may not be actionable because this person may not be in a protected class. In maybe the UK or the US, there might be laws that do protect people of these classes, and maybe this could be enough in those jurisdictions to say something.
Absolutely. And if I can just add something, it also the person's, for example, this producer's history can be looked at. We are in the age of social media. I am sure such a person would have said something 5 years back about trans women and men not being the same as women and men. And you can see some tweet he would have put up 5 years back, retweeting it for somebody who he his strong opinions on the binary of gender. And these are things that you can pull out to strengthen your case on the fact that this discrimination has always been there with respect to this person, and what he is putting in front as a creative opinion is actually just hidden discrimination. So that's also something that the people can try, since everything is public most of the time.
Just also a perspective that I'd like to add in here. Chetna, actually, you brought this up the other day when if this were in a public setting wherein the organization is a state-run or state-funded organization, then of course we can pick up a battle of discrimination under Article 14 and see where that could take us, and therefore the threshold is much lower there. But for private organizations, well, you have a choice, and you can be flat out, unfortunately you can be flat out discriminatory also there, and you can be public about it as well. You can't there are producers who would want to take say it is their creative and artistic liberty to be able to do that. So I ask myself certain questions when I watch certain series as well. If you watch Sacred Games, there are certain characters that why wasn't a trans person actually playing that character? And when I say trans person, I don't mean to offend anyone. I just mean it could either be a trans woman or a trans man. Playing the character of Cuckoo or Cookie, or but instead they chose to go with a woman who could then portray the character. And imagine that's a real life scenario that goes to this example as well. Just putting it in a public perspective really changes things. If let's say the ICCR, Indian Council for Cultural Relations, had funded a production like this, that would open the door to a much bigger remedy, a much bigger relief, much a better standard there, and opens the door for litigation under Article 14 as well.
Rashmi, would you like to add anything?
Yeah, no, I just wanted to add one thing, like how does one determine, and your question was that, how severe, I think many a times one of the parameters or indicators is also the impact which is caused on the person. And a lot of time we do this, especially, when I'm on the IC or various committees under the POSH Act, you decide the intensity of basically, recommendation, what action has to be taken after the case has been proven, that based on the impact it had on the person and also the impact it will have on the larger organization with similar identities. So I think that also becomes one of the parameters. Sometimes, because people will just say, oh, but only it was this much. So it's not about others deciding that how much that person should have felt. It is basically defined by the person, that how much it has impacted and what that particular incident or manifestation means to that person.
Awesome. This was an awesome discussion of this first hypothetical. We're going to move on to the second one. I think Shreya, you can go ahead and read it, and I'll ask some follow-up after.
Super. So a junior upcoming violinist is on a regional concert tour in India with the senior, well-known and well-reputed vocalist and midangist. So obviously we're speaking about a Carnatic music concert here. The latter two, the midangist and the vocalist, have a very long-standing relationship. Despite the violinist asking about the payment structure for the tour, he is denied any visibility into it by his co-artists and the tour organizer, and is handed a very bare bones contract. And then a lump sum is handed to the vocalist by the tour organizer at the end of the tour, ultimately allowing the vocalist to split the amount amongst the three artists. Later, the violinist is taken aback to find out he's only received 10% of the total lump sum, while the vocalist has received 50 and the mridangist 40. So what option does the violinist have here, and to whom will he go to address them?
Well, I think I can answer this question. The bare bones contract most probably did not have a clause which speaks about how much is going to be the share, and that plays a huge role in this, because either the violinist had the junior violinist had to ask before he entered into this bare bones contract to put how much will be shared between the three of them, so that he could enforce the right later on. But when there is no explicit statement in relation to how the money is going to be split among the three, he has to accept what's given to him. There is not much remedy for him unless he can prove that he was under duress or undue influence when he signed this contract. Then the contract becomes void of initio. But in a lot of these scenarios, especially you have mentioned it's a junior most person, they are scared of going against the seniors because of being blacklisted officially or unofficially, because the word passes around in the music circle or in the dancing circle that this person is very hard to work with, and he wanted to sue the senior, or he was threatening legal action against the senior, which kind of have repercussions for this junior to find more opportunities. So it's always ideal for you to clarify how much you're going to receive well in advance, and try to put it down in the contract. That will save a lot of trouble later on.
That's great. And unfortunately in our space, this isn't something that always happens. So because of that, can you talk a little bit about informal ways that people can register how much they're owed, so that even if they don't have it in a contract, they can be protected? So for example, what could this violinist have done preemptively to make sure that they got paid?
Here he has been paid, he's not just that the amount is low, initially when he was negotiating, and when the bare bones contract was entered into, and if he found that there was no mention about how much he's going to be receiving, for sure he could have sent an email or a message to the the seniors to say that I expect at least X percentage from the money you're getting from the organizer, then he has made the intention clear, and then the seniors would have come back to say that, no, you're not going to get that, or something to that effect, or if they kept quiet, then later on the violinist can claim misrepresentation from them because they led him to believe that he's going to get X percentage at the end of the tour. So that's one way of doing it. And the best option is to do it by email than messages, because given the Supreme Court thing, which I mentioned in my talk previously.
That's great. Do any of the other lawyers have anything to add here in terms of best practices or anything, Raphael or Chaitana or anybody?
I'll leave this to the two of them.
I would go along the lines of what Arun has said, collect a lot of information. If it's a bare bones contract and it's silent on certain key areas, especially consideration, I'm inquisitive to know what it actually pertains to. And if it's silent on consideration, then what we can do is we can show past payments for performances, and if they were performances of equal length and duration, we can really use that to show, okay, in the past, this is what has been agreed to. And we can try and build up an argument to show, okay, there was nothing to the contrary to say that this time would be less. And now this is an afterthought on the part of the seniors to show that. And we can kind of make up a case to show that, okay, the violinist had, sorry, is it a violinist or mridanganist?
Yeah, a violinist, yeah.
Yeah, the violinist agreed and even signed the contract anticipating or expecting the same fees as previous tour or previous performances. So that's one way to give us some legs to stand on. The other thing is, at this point, where does the violinist go from here? Of course, you don't have much leverage. You have to think of your future in the industry. Of if you are creating disputes for yourself with seniors who are giving you jobs, then they could talk amongst other seniors, and then you soon find yourself without gigs. But what could be done at this point is, if the contract is also silent on your performer's right, and if your video has been recorded, or if your image has been used to promote the tour, you can pressure the promoter, you can pressure the host, the organizers of the shows, and say your consent was not taken, there is some sort of breach there, and hope that creates some leverage for you in the situation, because in pressuring your client's client, hope a lot of times your payment gets cleared.
That's great. And I mean, those are all really, really useful reasons why having a lawyer drafted from the beginning can be helpful, because then you're not fixing things that could have been fixed maybe via one sentence or two sentences in a contract, but now you might be facing a lot more costs in trying to get the money that you probably would have gotten in the first place if you had just had it in there. And I think one of the issues that in this area is that oftentimes the amount of money that you're fighting over is very, very small. And so it might cost you more to actually defend it than what you're actually owed in the first place. So for anyone listening, that's why it's really important to sort of get ahead of these issues so that you're not spending more than what you're owed ultimately in sort of defending a contract action. So very, very helpful like tips and actionable items that you guys have given here. So thank you so much. I'm gonna move on to the third one. And it's basically a 14-year-old Indian American boy is invited to learn a few impromptu lessons by a well-renowned senior male artist from India who is on a North American concert tour. The Indian male artist praises his potential and asks him to take lessons at a private residence near him, where he is currently being hosted. The young boy enters the home with his mother. However, the artist tells the mother to wait outside while he takes class behind closed doors in a bedroom, claiming that the class needs privacy and focus. In the bedroom, the young boy is sexually assaulted during the so-called class and manages to escape for a few minutes right after the incident. He comes running out and tells the mother and host, an older woman in the local community, what just happened. How should the mother, the woman hosting, and the young boy proceed? Assume there's no contract or agreement that was signed prior to these impromptu classes with, a zero tolerance policy or anything like that. So any one of you can jump in. I think Chaitana is really well suited to address this, but any of you can jump in.
Yeah, so since this is something that's happened in US and not India, American law will apply, and please correct me if I'm wrong, Kritika, it varies state to state, right? Especially the criminal laws. So depending on which state this person is situated in, and if the child complains, I don't think nationality is about to, apprehend the person or put them in jail or subject them to the judicial process of US. So that can happen there. Should the mother wish to come to India and give a complaint, because that is something that I am equipped to advise, I'll just keep it very brief. They'll need to report it to the police station. Right now, at least in Tamil Nadu, online FIRs can be filed so this makes it a lot more simple with respect to not having to go to the police station and deal with an intimidating atmosphere. Also under the POCSO Act, not many people know, but police authorities, when they come to your house to take the child's statement, they usually come in plain clothes. You can tell them that this is a POCSO case. So, people in khaki clothes are not going to be beating down your roof and your neighbors wondering what's going to happen. They will be discreet about it should you wish to complain. Then after the FIR is taken on record, the person will be apprehended. The minor child will have to go before a magistrate and give a statement. This statement will form the foundation of the prosecution's case. Once again, if this child is from the US and has been exposed to certain amenities such as air conditioning, no dust, they are going to find the magistrate's court quite intimidating. Also, language may be a barrier. They are going to speak in the regional language, and to have somebody speak in English, you need a separate it can happen, but just to make sure that the fact that if the child does not know the regional language, that should also be made clear to the magistrate. These are some very small things that can go to the root of the trial when it does happen. Then after that, the child will be subjected to medical examination in a government hospital. So once again, a parent of an NRIs would want, they may have apprehensions, most of the times they just go to private hospitals because that's best suited. But in these criminal cases, it's a government hospital that you have to go to. So then after that, the case would actually happen in a child-friendly court. Now, slowly courts are having POCSO special courts. Whether the child has to come down in person or can attend the proceeding in video conferencing is a little tricky. If the child is not an Indian national, then special permission can be taken, in my opinion, for the child to have the speak to the judge through video conferencing. But this may be something that they'll have to go to the High Court for to get special permission to conduct this in video conferencing. At no point will the child have to see the abuser. And once again, I want to stress that, especially in the art field. Like, let's say a complaint has been given against a senior musician, and it's the December festival in Chennai, and that person is, let's say, just wandering down the halls where the child happens to be there. How do you enforce, and that they have gotten bail, how do you enforce that they can never see the child in this situation? That's going to be very tricky, especially in the art spaces where you work so closely together. If they are not going to class, one of their friends is going to their class. So the problems are magnified here. So if the parent wants to come to India and give a complaint, this is what they will be dealing with. It will be confidential. This is a special calendar case. It will be confidential. The name of the child will not go out. But at the same time, this is not going to be an easy process. If the family is somebody who can afford to spend on a lawyer, like I already said, they can maybe also afford a lawyer to assist with the prosecution. If they are not in India, it's going to be a little harder to keep tabs on what exactly is happening with the case.
This is all really, really useful information. So thank you for laying that out so beautifully for our listeners. A follow-up question that I had for the other people involved in this situation, for example, the host and the mother, what are their reporting obligations? Like, does the mother have the obligation to say something about this? And are there repercussions in India if the mother fails to report it? Or are there other, let's say the tour organizer is based in India, are there repercussions for that person? If someone knows something happened, what are the reporting obligations there?
That's a really, really good point. But for this situation, I think it's if the reporting manager is in India, then it's a little tricky because the act itself didn't happen in India. So if they've already reported it in the States, I don't think the reporting manager is obligated to report that act in India. But let's say that this is an incident that happens in India. In this case, if the mother comes to know about it, or if the program coordinator comes to know about it, yes, they have a mandatory obligation to report under the POCSO Act. They will have to report it to the police, who will then further take action. But the whole this thing of going to the police station may be minimized if they want to file an online FIR. And the process of filing an FIR itself, I'll just very quickly tell it. Before you get an FIR, you get a CSR number. Then after that, you get an FIR. Once an FIR is registered, comes the charge sheet. Once the charge sheet is framed, that is sent to the district court, who will conduct this POCSO case. So this is how it plays out, and the entire proceeding for it to culminate, since the accused lawyer is going to do everything in their power to make sure that the case does not end or terminate, can even take up to 3 to 4 years to conclude. The child's age is also going to be difficult here. Let's say it's a 17-year-old child, then they will definitely, its age is a very, very important factor. So I suggest that they have their birth certificates ready, the child's school certificates ready. And because the doctors would want to conduct medical examinations to actually ascertain their age, because if the child is, let's say, 18 and 6 months, that once again is scope for the accused to say that no, they're technically not a child and cannot be tried under POCSO.
Thanks so much. And Rashmi, if I could quickly ask you, since this is probably a very common case that you deal with in your day-to-day work, what type of role would you play in this situation, and what advice do you have for parents in this situation who are facing a child who has been assaulted or any sort of misconduct that their child has faced? What are some things they should do, and what are some things they should not do, and common mistakes you've seen?
One of the things which technically PCVC is legally not allowed to deal with is the cases on child sexual abuse, because one is that we don't have the permission to do that, we don't have the skills and the infrastructure. Many a time we have seen that if children are accompanying their mother or parent to the shelter, and if there has been a case of child sexual abuse also, then we refer them to the different organizations who are there in Chennai. So we are very, very clear about it, because it's better not to go wrong instead of jumping into everything. And right from its inception, PCVC has been very, very careful about that. Coming to let's say, the person comes with such a case to PCVC, calls on the number and says, I think one is, of course, through our psychosocial interventions. One of the things which definitely PCVC and organization would do would be to talk to the parent and make them aware of the impact an incident of this can have on the child, and what are some of the risk assessments PCVC would do along with the parent, that are what are some of the risks, what are some of the threats, and what are some of the safety measures which as a parent they should be taking. So it could be right from not letting the child to be alone, being with the child, not sending the child to that same person, to the same institution again. So I think that's the role PCVC would play. And of course, as I said in the beginning, that we have referral organizations on board. Immediately we will connect the child and the parent with the organization who's providing these kind of services. And they might be an NGO only, but again, the NGOs are that people who are working on child rights, they are more geared to work directly with children. We are not legally permitted to do that. So I think our work again will be with the parent and how we create that kind of a safe environment, because many a times parents themselves might not be aware that how do they deal with something like this, and also as a society there is a lot of things where as a parent we might just keep blaming the child also, that maybe, I don't know what the child must have done. Right from, our childhood, we have seen that a lot of time there is silence around these issues because that's the way we grow up with that. Okay, this is not something. But in this case, where we are very clearly saying that the child rushes out and tells the parent that this is what has happened, then I think it's more about working with the parent that, how do you engage with the child?
Great, thank you so much. If any of the other panelists have nothing to add further, we will move on to our very, very last hypothetical. And the hypothetical is: a Chennai-based folk artist with limited English language proficiency is hired to be a part of a studio music recording for an upcoming standalone production by a prestigious dance company. The contract presented to them is in English language, legalese. However, this folk artist is unable to understand the contents of the contract and does not have the network or means to hire a translator. The organizer, despite being aware of the artist's unfamiliarity with the English, provides an ultimatum and asks them to sign within 24 hours. Strapped for money, the artist feels left with no option but to sign. And after the recording is finished and the production releases, the artist finds out that the organizer has used and distributed the artist's creative IP without their knowledge and has benefited from those proceeds. The artist was told the recording would only be for one dance production. However, it was used for several and licensed out to use by other production companies as well. How should this artist proceed? I think, Raphael, you're in a great position to sort of take the first stab at this, so go for it.
Quite recently, we had a matter like this where we were trying to get a folk artist to sign an agreement that was well drafted in English. And just to be clear, why do we do this? Why do we get both parties to sign an agreement where one party may face a disadvantage in language, right? The reason we do this is so that when in case of a dispute, and if that dispute is litigated and that dispute goes before the court, we don't want there to be any room for interpretation or a difference in interpretation between, let's say, an English version of the agreement and Hindi or Tamil or any other language version of the agreement, because that can happen. And I'll give you an example, a really big example of this is in India, we have stamp duty, right? Every kind of instrument has to be stamped and the appropriate stamp duty has to be paid, or else the document cannot be admitted into evidence in a court. Now, if you look at, let's say, the Bombay Stamp Act or the Maharashtra Stamp Act, as it's called today, and I'm sorry, I'm just going into this for a minute, but maybe it's worth the point. If you look at the Bombay Stamp Act, now you have an English version when it was the Bombay Stamp Act, and you have a Marathi version that came out, I believe, in the amendments late 90s, right? And now English is the official language for the most part at a central level, at a union level. English is the language in which legislations are passed, and that is the authoritative language for interpreting legislations as well. They do have, of course, official translations. When it comes to state laws, it is. I mean, the central government had, I believe, can't remember the specific act, but the official translation of the local language in which the act was passed is supposed to be the authoritative version. And if you look at the Maharashtra Stamp Act, specifically for the entertainment, and this concerns us a lot, you have one provision. The English version says specific performance by an artist, whereas the Marathi version, if you literally, it says Visheshta Karyakram, which means special performance. Two very different things. And in English, it was translated to specific performance, which is not the same thing at all. And it doesn't have any context in amongst those articles, right? And just because of those different words being used, we have to pay double the stamp duty. So from 0.25%, it is now 0.5%, just because of those words. And now, of course, we can argue and say, well, that's not what was meant, and someone made a mistake in translating it and things like that. So this example is just to show you, to give you some background on why we ask both parties to sign the contract in the same language. We do try and, at least I try and create a translation, but that is only for reference so that the person can ask questions based on the translated version. But we don't get the translated version signed. And I acknowledge there is a disadvantage, but this is kind of the best we can do to protect both parties in the case of the dispute. So somewhere there is a compromise. But now in this present case, what can this folk artist do? Yes, the folk artist can dispute and can say that the entire agreement is void because there may be free consent, but remember, consent is consenting to the same thing in the same sense, right? And that argument, you can never shut the door. I believe you cannot shut the door on that argument ever, especially in this arrangement. The courts will look at what if there was an understanding to the contrary. Once you state that there was this disadvantage, if there was an understanding to the contrary, let's say the person who presented the agreement said, yes, the usage is not defined in the agreement, ownership is defined in the agreement, but usage was not defined in. So, but let's say on WhatsApp, the promoter or the producer told the folk artist, we will only be using it once and streaming it once, but now it's being streamed and sub-licensed everywhere. Definitely the court will consider that, will look at it and say, well, I will have a doubt at the back of their head before they say, yes, this was something that was consented to. This is, one of the easier questions to answer in the case. You just directly go out and question consent here. And that could render the entire contract void. So that's something the artist should not feel that they're in a position of weakness. In fact, they're in a position of power. They should think about the millions of, not the millions, but the lakhs of rupees spent on drafting that contract and executing that contract, because just this one word could actually void it.
Awesome. You went through that so amazingly that I have zero follow-up questions for you because you just sort of answered all my questions. So thank you so much for walking us through that. Before we conclude today's session, I just want to go around maybe 1 or 2 sentences for each of you on some key takeaways that you want our stakeholders listening in to take away from. And you can talk about generally your practice area or general advice, whatever you feel is relevant for them. If they leave the session with nothing else, what would you want them to remember?
What I would say is I started speaking about the big guys earlier, and now I'd like to speak about the little guys. So, I don't mean to belittle anyone. I'm just being clear here. But I mean, individual practitioners, professionals on their own, right? This session is I'm a professional too. And if you're an individual practitioner, individual professional, I'd like you to understand that you have, especially in the creative industries, for infringement of copyright and trademark, you have criminal remedy. And what that does, it's very easy to say criminal remedy and spook everyone out. But what that does is it puts the entire machinery of the state behind you. And then you're no longer the little guy. So the moment you file for your case, and it's not like, in the case of a private complaint, it's a bit different. You're not responsible for leading the litigation. Of course, you need to get the police officers, you need to get prosecutors to understand what your claim is. And that is your responsibility. That's going to be your responsibility. But the machinery of investigation, the machinery of raids and things like that, that's not something that you need to set up. You don't need to hire private investigators. That comes to you with this criminal remedy. On the civil side as well, like Chetna pointed out, there is legal aid that's available. You can, in different forums, different courts, you can find lawyers, there used to be, I mean, we still call it a noble profession because you're supposed to put the brief in our pocket and the consideration at the back of our gown, and we're supposed to take it on. So maybe try that as well, see if it works. But the point is, you should never hesitate to seek legal advice. And do not sign anything until deadlines. Believe you me, everything is urgent when a client reaches out to us. There is no urgency. I like to believe that there is no urgency. We're the ones who also, we're guilty of telling other parties that that it's urgent, needs to be signed in 24 hours. But you push us back, everything revolves around you, especially if you're a creative, right? And of course, you may be replaced, but it's better to be replaced than to have a bad deal and to sit fighting. Like Arun said earlier, short term, you may be satisfied, but long term, the cost of hiring the appropriate lawyer, battling this out, that's going to be tough. So yes, always reach out to a lawyer. Know your rights. Do not get into that silo thinking that you're just this small person in an ecosystem. You actually have some of the best rights, the largest rights out there.
Thank you so much. Chetna, do you have any closing remarks?
Sure. I think it just ties back to what we first started. Justice or outcome of the case really varies from person to person. By all means, please share your stories, please compare notes with what has happened, but please don't for a second think that both your solutions have to be identical. It really depends on what each person is capable of withstanding and fighting for. And it's okay if you don't want to fight also. That's also something that I want to also always make very clear with people. It's really, at the end of the day, it's what your mental health and your physical health can withstand. If you can manage a court of law, and if you have it in you to contest a case of 5 years, that's great. If you're okay with an apology and you want to wind things up, that's great as well, whatever suits you. And second, I think Rafael said it very beautifully. Please don't hesitate to seek out legal assistance. There will always be somebody to assist you. There are also blogs that are there present in the Indian scene where you can post a legal doubt and they answer. There are some shady replies and it's not 100% accurate, but I'm telling you that even that you can get some kind of legal assistance like that. The avenues that are open now because of social media, because of Twitter, because of LinkedIn, because of Instagram, the lawyers are also accessible on these platforms. Granted, we are not as glamorous. We are there with maybe single-digit followers, and you can find us if you want. But just remember to cast your net out wide when looking for legal advice. That's all.
Awesome. And Arun?
No, it makes it easier for me just to say my learned friends have covered everything and get an escape route. But I just want to add a couple of things to what Rafael said. And I agree with whatever he said. Reach out to us. There are lawyers who are willing to help you. And there are some lawyers who work on a no-win, no-fee basis. I don't do it personally, but there are lawyers who do that. And then look for, if you're not in a position or if you're not comfortable to reach out to lawyers, at least read up on your rights online. Like Chetna said, there are blogs on your rights. So when you're negotiating your contract, you know exactly what you're getting into. Even though I always tell my clients, for two things you cannot rely on Google. One is medical advice, another one is legal advice. But if you have no other option, look for contracts. More sample contracts are available online. Look at different contracts, because not one contract is going to suit your needs, because your needs may be very specialized. But you can, by looking into different contracts, you get an idea of what you're looking into or what you're getting into, and that will help you to make up a decision. Okay, this is not for me. I should get a lawyer to talk about all these things. Yeah, that's about it. Thank you.
I think I would also like to say that one is reach out for support. There is support available of all kinds, whether legal or not legal. And I think the first action is not something where you start doing something about it. I think the first action is when you even start thinking about it, that what I am going through recognizing that, and even like coming to a point that what I'm going through is something shouldn't be happening, I shouldn't be taking. I think that's where the journey begins. And I think that's where, it should be. So I think my message would be reach out, and there's always support available.
Thank you so very much, Rashmi, Rafael, Chetna, Arun. Taking time out during the Diwali weekend is not something easy, and it's not something we're taking for granted. So thank you so much for taking some of your time out of this. I also want to just say how fabulous it's been to co-moderate this with Kritika, who's just coming back from our honeymoon and everything. So congratulations on somehow doing this together across continents. Also, big shout out to Janani from CAREspaces, who's been handling the tech for this call, as well as Sneha from SNS from our side, who's been managing some of the logistics and admin. So a big shout out to them and to our respective CAREspaces and SNS teams who've been working so hard to put all this together. This, like I say, is a series called I'm a Professional Too, and this is the 4th session. We have one last session as a part of this section of 5 coming up on November 21st. It's called Draw Your Boundaries. And we will be posting the link on the YouTube chat for the RSVP. These sessions are free, but it will be available first to the people who RSVP, as well as all the other handouts and other information that we're also giving out with these sessions. So thank you everybody who watched and listened and was sharing the content, and thank you again to our panel. And happy Deepavali.